A lot of people are interested in do-it-yourself probate, and there are a lot of good resources available. I'm Lynn St. Elder Law Attorney, and we help clients with probates. But what I want to talk with you today about is more about do-it-yourself probate and what do you need to know to make the decision whether that's right for you. First of all, let me explain. What is a probate? A probate is the legal process to administer an estate when somebody has died. So what it means is that the will is taken and filed with a court. There is a petition that is filed and the court signs an order, says yes, this will is valid, and then gives the legal authority to the executor, the personal representative, to be able to administer the estate. And what that means is pay any creditors' claims, bills, gather up all the assets, and distribute them out where they're supposed to go. So it sounds really easy. And that's why a lot of people say, I can do this myself, save the legal fees. Totally understandable. In Washington state, just like every state, there are very strict, specific rules that have to be followed. And that's where people get into trouble, because you can get a form online, and if you're looking for online forms, look for Washington specific forms. There are also services that will fill out the forms for you. They'll give you the forms, they'll fill them out for maybe $600 or so. So that is one option. But what happens, the problem is that people, once they have the forms and they file them with the court, and there is a filing fee, it's $240 in the state of Washington to file them, and then the letters cost $5 each. But when they get this, then what? What's the next step? This is where people get into trouble, because you've opened the probate, you've got your letters, now you don't know what to do. There are so many procedures that have to be followed. So what we find is, once people have opened a probate, then they say, I don't know what to do next. That's usually when they seek the services of an attorney, because they didn't know that they have to give notice to the heirs at law, to the beneficiaries listed in the will, to the state of Washington Department of Revenue and Office of Financial Recovery. They don't know how to publish notice to creditors in the legal newspaper in the county. Then they don't know what the next steps are if they do get a creditor's claim, and it just goes on and on. I'm not saying this to try to overwhelm you. I am explaining what we find when clients, when they've started it on their own, in a very good intentioned way to take care of things themselves, they often run into troubles. If they do that, please reach out to an elder law and an estate planning attorney. Now, why do people not do that? They're trying to save money. That just completely makes sense. You're trying to save money, you're trying to preserve what the assets of the estate are. But when people get it wrong, when they don't do things right, when they don't give the correct notices, a lot of bad things can happen. Potentially the will can be challenged. An heir can come forward, a beneficiary can come forward, or maybe the state of Washington has a lien. Or maybe there's a tax lien. There's so many things that are threats to the estate, to the proper distribution of the estate. And if people get it wrong, not only is it difficult emotionally, but it's difficult financially. And potentially it can eat up the entirety of the estate, and then it becomes an insolvent estate. So there's a lot of reasons why you might want legal counsel to help you. And again, yes, it does cost money. You can expect legal fees can run $5,000, $10,000 on a probate, and that really puts people off. They do not want to pay that money. I can tell you though, if people get it wrong, what happens is that those legal fees can just multiply. So sometimes it's just best to pay for that legal counsel. Download our free probate checklist by clicking the link below.